Welcome to Looking at Legal Stuff. Today we have 6 hearings in an emergency minor guardianship after a 17-year-old girl and her grandmother petitioned the court to allow her to stay with her grandparents due to her mother's poor choices, which have led to an unstable home life that is affecting her mental health. Also, they just moved in with Mom's new boyfriend, and she doesn't like how much her mom's new relationship reminds her of the past partners who committed DV. She wants to live with Grandma until she turns 18 in 6 months. Mom says this whole thing is ridiculous, and the only reason her daughter wants to go live with Grandma is to avoid being punished. Mom says her children are addicted to technology, and her daughter is just rebelling against having her cell phone taken away. Let's see what the judge thinks.
All right. And it's Miss Gilliam, correct?
Yes, sir. Yes, Your Honor.
And we have the father.
Yes, I'm here.
All right. So, Miss Gilliam, what's your position about this?
Well, Your Honor, originally this started out because my daughter was grounded from her cell phone, as were all the children in the house, because we had indicated that we needed them to get some chores finished, basic household chores. And then when we found that the kids were on their phones, we took the phones as punishment over the weekend because nobody had done their chores. My daughter, Samantha, had contacted me twice from a cell phone that she had been grounded from. The second time was rather confusing because the first time I thought I had the phone in my possession. It turns out it was a second phone that she had. When she called me the second time off of a phone that I thought I had grounded her from, I was confused because the phone was in a locked bedroom in a nightstand drawer. Because of my daughter's very apparent addiction to technology and with some of the questionable things and behaviors that I've been seeing over the last few years and more recently the last few months, my intent was to eventually go through the phone to kind of figure out what was going on. After I had a conversation with my daughter about she needed to put the phone away and she needed to leave the phone alone and I would talk to her after I got home from work, I received a text message from my mother saying that she had gone to the house and picked up my daughter and that she was going to keep her for a day because she was upset about something. I then told my mom that Sam was in trouble for lying to me about a phone and that she needed to go home. It was a school night and that there was no reason for her to be taken from the house. It turned into a day or so texting conversation about how I needed to go have a talk with my mother about Sam, implying that that she was not going to be returned to me until I talked to my mother about whatever it was that was going on. A couple days later, I got a visit from a CPS worker with the claims that are listed in the original petition for the immediate guardianship. We spoke with CPS, we discussed everything, and then over the weekend, I attempted to retrieve my daughter from my mother, but then I was informed that there was paperwork in the process for emergency placement and that I was not allowed on the property and that I was not allowed to go retrieve my daughter from my mother's care.
What
happened
with the report, the referral to CPS?
From what my mother and I actually went and had a meeting with the CPS worker on Monday because part of the order is that they're requesting that all of Samantha's belongings be returned to her by the 28th of this month. While I was going through her belongings to gather everything up in the case that the guardianship is granted to my mother, I found some very disturbingly graphic items in her belongings as far as art, different things that have been happening online.
Let me stop a second. Let me ask the question again. So what was the result of the CPS investigation? Has it been concluded or not?
No. No. As we had a meeting with my mother and I had a meeting with the CPS worker on Monday, and she told both my mother and I that the case is going to be closed because the claims in the original complaint are unfounded.
Okay. All right. So, Mr. Breitmeyer?
I honestly don't have much of a position. I am 2,000 miles away, and all I know is what I've heard from each person I've spoken to. I did try to contact Kirsten, but her number had been changed and it appeared that I was blocked on her Facebook. So I was having a really difficult time contacting her to get her side of the story. What I did receive was a very disturbing conversation from her mother and from my daughter Samantha, and I cannot and I will not say anything against Kirsten because I do not know. The things that I did hear though were very disturbing.
All right.
And it sounded like from what information I've got, it just sounded like maybe it was the best idea for her mother just to take her. I mean, she's going to be 18 in 5 months. And it sounds like there's a lot of stress going on at Samantha's home, and her mother has the resources to get her the help she needs.
All right, Miss Gilliam, there are some allegations about a boyfriend. Anything you want to say about
Yes,
that?
Your Honor.
What do you want to tell me about that?
Those are the claims that were made to CPS, and CPS found them to be unfounded. Mr. Smith has a history of having CPS complaints made against him by his now late ex-wife and his ex-sister-in-law in retaliation sorts regarding the divorce and him having primary placement of his own children in his own home. Because of the history.
So his children are in the home as well as your
Yes, Your Honor. He's had primary custody of his children since the divorce.
Okay. All right. And Ms. Costin,
Since
you want to tell
2015.
me?
What I would say about this, Your Honor, is I know that there's a history of volatility and instability and multiple issues in Samantha's background and raising. For example, she is a senior in high school now, and this is, I think, her 5th high school that she's attended since she was a freshman, for example. There's been other issues along those lines. I don't think that what happened over the cell phone was really the issue of what happened. I think Sammy's reaction to the cell phone is a cumulative effect over her experiences that she's had throughout her life. Based on what Sammy has told me, there's a lot of behaviors in the home, especially by Kirsten's new boyfriend, that mirror closely what she has seen in other men that have crossed paths through her life. And so in fairness, I don't think that she is reacting as strongly to Mr. Smith personally. I think Mr. Smith is too close to other behavior that she's seen. I have told Sammy and her older sister for years that if they were ever in a situation where they felt really unsafe and that they needed to get out, they could call me anytime, any place, anywhere. I would go get them and make sure they were safe. And then when everybody was calm, we would have a conversation about it. And I've told that to Kirsten too. And that's what I had tried to do as this thing launched. Since that time on Monday, September 11th, when all this started, there's been volatility in the text messaging I've received from Kirsten. Some messages seemed more willing to discuss the situation and work something out. Others were very demanding and made statements like she was coming to my house at 8:30, 9 o'clock at night when I am typically in bed. She's also texted that when Sammy goes back to her house, we're not to have any contact with her. We're not to make any effort to have contact with her, so long as Samantha is residing in her residence. So the isolation of the location of the residence, the things that Sammy has been talking about, all coupled in a totality of circumstances situation. I don't think that Sammy being there is going to be conducive to getting her some of the help she needs to deal with the mental health issues and her newly disclosed substance use issues that are in play in the situation.
All right. Thank you, ma'am. And that sounds unfortunately like not.
Your Honor, I would like to make a
presentation. Hang on, ma'am.
I would like.
Ms. Gilliam?
Yes, sir.
Well, here's where we're at. This is not a custody proceeding, it's a guardianship proceeding. The relevant inquiry for me right now is whether or not there is no parent or guardian willing or able to care for the child, and that's just not the case. So I am going to order the child returned to Miss Gilliam by 5 p.m. today. Miss Gilliam, obviously there are some serious issues going on in the home. I would suggest to you that probably the best way to make those a lot worse is to cut your daughter off from your
Honor.
grandmother. You understand that? Miss Gilliam, you understand what I'm saying?
Yes, Your Honor.
Yes, Miss Cost?
You're on. Sammy, come here, please. Sammy is crying.
I
And
understand that.
do you want a chance to talk to the judge, Sammy? Because now is your chance. Come here, honey.
He needs to.
You need to come have a say in this.
Yep.
Just pull your chair over here.
For yourself, kiddo.
Take a breath.
Samantha, take your time. Is there something you want to tell me?
I don't want to go back, Your Honor. I apologize for the shakiness in my voice.
Okay.
It's very emotional. For the last 17 years, I have been subjected to mental, emotional, psychological abuse, threats of being killed, threats of our mother being killed, or our pets or harm to come to us if we ever tried to leave the situations. And my mother has a habit of covering it up with they're loud or that they need help or it's their mental psyche that needs to be checked out in order to fix the problem. I don't feel safe in that household because of past experiences and things I have been told from the children in that house. And
take a breath. Big breath.
I had mentioned to my sister that I felt like I was either going to die by their hands or mine because of circumstances, and it had gotten so bad that through the relationships, I have started contemplating suicide and self-harm, where 2 days prior to the call made, I was thinking of the attempt to break that chain of the abuse because I couldn't tell what was going to happen, and I was fearful of getting harmed when my mother came back to the house because I wasn't aware if Nicholas was with her or not from the claims he has made over the phones into his children of me. I do not feel safe going over there, as it has been stated that I would be put on suicide watch by the adults in a camper that is offside of the house. I don't want to be isolated, and I feel a lot safer here in knowing that I have nightmares of being dragged back to that house. Multiple in one night doesn't make me feel safer if going back there is the option.
Deep breath.
I had explained to my mother this wasn't over a phone and that it hadn't been, and that it has been the course of said 17 years of abuse and neglect. And she had gone back around and said it was of the phone after hearing me over what I had told her. And she has made claims against me.
Deep breath.
That I had spoken to her about. And in the paperwork provided, she made her list of things and reasonings. And with the substance abuse were provided by her and whoever was in the home, such as the alcohol. The weed was with someone we were living with at the time named Jay, and it ended up with my sister in the hospital for using it on medication. And I'm going off of what I remember. I'm so sorry. I don't want to go back there, genuinely. And if it makes it better, I would want to request a guardian ad litem.
There's your statement here.
I have also been on the side of abuse, verbally, mentally. I have been called mentally slow. I wouldn't amount to anything. I have been told by her previous ex-husband I was the reason why I didn't stop my own molestation. When we got into an argument over my sister, I've seen and heard my mother be abused in situations that I shouldn't have been a part of. Yes, I will admit I have drawn and written very dark things since 6th grade, but that is all because of the trauma that has welted up and significantly grown in strength throughout the years. And since being with my grandparents, I feel more comfortable, and I feel like I don't have to be scared of waiting for something to happen to me when I get home, or when I'm told I'll be spoken to, or I hear something that the adults say that are very negative about me or towards me and what feels like an attack. My mother has said I have had mental problems, and there have, for the last couple of months, has felt like there has been little to no help to try and get those seen, because when I have spoken to her on the accounts of I don't feel safe, I don't feel comfortable, something is wrong, I have been pushed off and told, Nicholas is just loud, and I get you're stressed out, we are all stressed, but had disregards for everything I had said. And on the night that I returned on Tuesday, I explained to her everything on why I had chose to leave. And she said that she heard that she was still my mother, and this didn't make her any less of it. But her actions after that have proven to feel otherwise. I felt like I've been isolated from my own family, including her, at that household, because of the way she is acting and acted. I don't want to go through another situation to where I feel like I have to worry for my own life or my own safety if that goes between their hands or mine. And I am hoping that I get to stay with my grandparents, because here I have a chance to actually have a life from what it feels like. At that other place, it does not feel as such. It has taken... I'm sorry.
Deep breath.
Good job, sweetheart.
It took so much that my sister had refused to go back home with her as well. When we were moved to Kansas my mother had moved me and my sister to Kansas to keep us safe from Ryan, is what she had explained to us. And Hannah did not want to go back and refused to go back into her custody over that. And throughout the months, and I've been messaging her, or have messaged her, my feelings, my thoughts, and how scared I am. And with Nick claiming to be a concerned father figure, I don't know him. He only knows what my mother has told him of me. I have only met him in person when I was moved to the house.
How long
And
ago
I've
was
ever only
that?
spoken to him on call 3
How
times.
long,
Your
how long
Honor,
ago was that? Hang
Your
on.
Honor, we moved
Miss Gilliam,
from,
hang on.
yes, Your Honor. August 10th,
How long ago was that? Samantha,
August 10th is when,
Miss Gilliam,
She's asking you a
third
question.
time.
I'm so sorry.
Samantha, how long ago was that?
How long ago we moved here?
Yes.
Around August 10th, as my mother says.
All right, Miss Gilliam,
I'm sorry, Your Honor, I thought you were addressing me with the question of when we moved here.
what else do you want to tell me?
Well, my daughter is right. There has been a lot of turmoil in her life. There has been a lot of moving. There has been a lot of upset. There has been a lot of things that they have experienced by proxy because of choices that I have made in my life. I have tried. We left to Idaho in 2017. And in the time that we had been there, I had taken my daughter to several different mental health professionals, to several different doctors, because she has told me that she struggles and that she needs help and that she wants to see somebody. During the course of that, it either turns out that I take her in for the appointment for things that she needs or says that she needs, and then she doesn't talk to anybody about it, or she will back out of the appointment altogether. I've been in Washington 6 weeks. I just recently got signed up for food stamps, and I have the medical insurance in process, but because they have to verify that Idaho is no longer carrying medical benefits for her, I have to wait. I don't have an issue with Samantha seeing her grandparents or being involved with her grandparents. I had an issue with the events that occurred that weekend. Was in my perspective, I was reprimanding my daughter, and then all of a sudden it turned into this big thing. But because there were things that I have discovered that I have not been able to talk to Mr. Breitmeyer, to her dad about, it's turned into this whole convoluted mess.
How far away from the grandparents are you living now?
So my mother lives up behind the country club, and we lived on Headquarters Road in Castle Rock. So 15-20 minute drive, give or take, for traffic. And over the course of all this, in the time that we've been here, I have had to get a new job. I've had to do Samantha moved schools. Originally, we were going to stay in Idaho for the remainder of her senior year, but there was an issue with my vehicle, and my vehicle broke down, and my two choices were to either pay for the vehicle and not be able to pay rent and lose the house, or pay for the house and not be able to get to and from work so that I could sustain our living situation. Mr. Smith and I've known Mr. Smith since I was 13. We've been friends for a very long time. And when I spoke to him about the situation, he invited us to come here, which was great. We were going to be closer to family. Sam hasn't spent a whole lot of time with her grandparents because we've been in Idaho for the last 6.5 years. In the last 6 weeks, I've had to get medical. I've applied for food stamps. I've started a new job. Nick had to tell his kids that their mother passed away a week before this whole thing started. And it has been one hit after another. And I know that Samantha feels uncomfortable. I know that everything feels rushed, but I am doing my absolute best to get everything situated for her. But I don't make enough money to afford a private pay medical insurance. My job doesn't offer it. And the only way that I can get medical is either to have her on state Medicaid, or unless there's some way that her dad can carry state Medicaid for her somehow. And she was living with her
If
dad
I
for a
had
period
her,
of.
I could get her medical
Mr.
right now.
Breitmeyer?
Sorry, Your Honor.
Yeah. No, and Eddie did have her for a period of 9 months, and she seemed to thrive, but there was an issue with housing at some point, and it turned out that Sam had to come back to Idaho with me.
All right.
And then, but I've been here for 6 weeks. We moved here on the 10th, and in that time frame, I've been applying for the state benefits so that I can get her into somebody to help her with her issues, but they haven't, because they have to confirm that Idaho no longer carries anything. I have to wait. And like I said, I don't have an issue with Samantha having a relationship with her grandparents. I don't have an issue with her seeing anybody that is part of her family. And she's not at risk at the house. She's not. There has been some issues at the house, yes, but that was due to a couple years ago, Nick's dad was murdered in his home. And then he moved his 15 years of life with his 2 children into his mother's home to try to help repair everything. And then he suffered a heart episode in March that he's been recovering from. So he's been trying to take care of a 2-acre piece of property with no help after recovering from a heart issue. My daughter is not at any risk. I mean, yes, I am frustrated and I'm irritated with the way these events have happened, but I'm not angry at my daughter. I know that my daughter needs help. And I will do whatever I can to get her that help. And if that means that she feels that she would be better off with my parents, then maybe that's the route that we need to go. But all of this, it's heartbreaking. And the only thing that I want to do is help my child.
All right, Samantha, can you hear me, dear? Are you enrolled in school?
Yes,
Where at?
I'm at school right now.
Okay, and have you talked to the school counselors there about getting some help for the issues that you've raised?
Not to the specific counselor, no.
Didn't you
Okay.
talk to the woman across the street?
I
though?
did though, but she isn't part of the school.
Oh, okay.
Okay, so Samantha, first of all, I want you to understand, I'm not discounting or disbelieving anything you're telling me. Okay. Now, having said that, there's standards that I have to go by. And so I have to dismiss the guardianship petition. Okay, so number one, please, until some other services are in place, go to the school, talk to the school counselors. That's number one. Number two, Ms. Koss, I understand exactly why you filed this. If I was in your position, I probably would have done the same thing. Okay. I'm saying that to not discourage you from filing a second one if things go as you think they might.
Okay.
Ms. Gilliam,
Yes, Your Honor.
it sounds like A, there's an awful lot that's got to be done before your daughter should come back into that house.
Yes, Your Honor.
B, the best way you've got of completely destroying your relationship with her is to force her back into that house.
Well, at this time, Your Honor, based on my daughter's reaction to all this, I am not opposed to her staying with my mother until all of us can sit down and actually talk.
I think that's probably an excellent idea. And I think that probably shouldn't happen until after that counseling's in place and Samantha knows that she's safe and going to remain safe.
Yes, Your Honor. So my mother gave me a packet for Core Health, but they won't see her without insurance. And like I said, I'm still waiting for her insurance to come through. Do you know of anywhere that I can find a place to sign her up for services until the Medicaid is in place?
I wish I did. The one thing that I know can happen is if you sign a temporary custody agreement with your mother when she's got her, then whatever insurance they've got generally can cover that.
Okay, well, from what my mother and I have spoken a little bit about that. From what she said, for whatever reason, Sam can't be added to her insurance, but I'm not quite sure why.
Well, it might be because you lack that agreement for temporary custody. So Ms. Koss, check with your insurance about that and see if that would resolve that issue.
We will take care of that.
Okay. Yeah, this is one of those circumstances where I hope everybody acts with a great deal of compassion and concern and goes very, very slow.
Yes, Your Honor.
Okay, Samantha,
Yes.
sounds like your mother heard everything that you said too. You understand that?
I'm just worried that it will come back around in a series of bad texts.
I'm not telling you not to be concerned about that, but from what I'm watching here, you're not being ignored. Okay, so take some comfort in that. Get to school, go talk to the counselors there. Sounds like you and your mom need to have some phone conversations just to keep the lines of communication open. That makes sense?
Yes.
Okay. Mr. Brightmeyer, obviously
Your Honor.
they got a ton of work to do. To the extent that you can support either one of them or both, I'm sure it'll be helpful.
Oh, absolutely.
Okay. All right, so I will sign the order dismissing, and I hope it goes well from here. As I said, last thing I want to leave everybody with is Ms. Cost. That is not a indication that you should not consider filing a second one if things don't go the way that we all hope they will.
Thank you, Your Honor.
I honestly do believe that it would be the better choice to be with Miss Tammy Cost.
And that may or may not be the case, but that's not the standard that I have to follow.
Yeah.
So
I understand that.
all right. Okay, thank you all.
Thank you,
Thank you,
Your Honor.
Your Honor.
Guardianship of Samantha, is it Brightmeyer?
Correct.
Okay. And I see Ms. Gilliam present. Thank you for being here. I see Walter Cost. I see Tammy Cost, and then Nicholas Smith.
Yes, Your Honor.
Mr. Smith, what is your role in this case?
More or less moral support, but all the claims have been made against me, so could be a witness potentially.
I see. Are you Ms. Gilliam's significant other?
Yes, ma'am.
Okay. So why don't you go ahead and just mute, because you're not actually a party to this case, but these are open proceedings. You're welcome to be here, but go ahead and mute yourself. All right, so I guess I'm a little concerned, Ms. Cost. I'll first come to you. I was not the judicial officer involved in your initial hearing. But to me, what it does look like is that there was a motion hearing as recently as September 21st, where Judge Warning actually took testimony, denied your petition, and indicated his ruling that you transfer child in increments slowly. He wasn't anticipating it would be same day, but he did anticipate that you would be transitioning child back to mother, as he found mother able and willing to serve as a parent. So why are we here again?
First of all, Your Honor, I would just want to alert the court that Samantha is present next to me. She has said she does not want to be present on video for this.
Okay, how old is Samantha?
She's almost 18. She'll
Okay.
be 18 February 1st.
Did she have an attorney when this was originally heard?
She did not. One of her requests moments ago was that if possible, that a guardian ad litem be assigned to the case for review and then report to the court.
Well, so, well, first, before we get there, I guess, Ms. Cost, what have you done to comply with the judge's ruling to transfer child back to mother?
So after the ruling, I had contacted my daughter by text, asked her if she was interested in working out a parenting agreement, and I got zero response on that topic. 2 days later, I received a text, and there should be a copy of it in the record, stating that she was waiting for a copy of the final report from the court, or the final document with the judge's ruling, and the closure of the CPS case. The text was sent on September 23rd, 2 days after the ruling in court on the 21st. Said afternoon, so after a lot of thought, I've decided Sam can stay with you until I have written verification of the CPS case is closed and a copy of the final order. Once I have those, I'll get in touch to make arrangements to get Sam. So added to that, and Samantha's expressed fear and concern over Mr. Smith's behavior, and Kirsten residing in the Smith residence. I don't know if you got a chance to listen to Samantha's testimony on the hearing of the 21st, but she put a lot of detail as to the experience of being raised in environments where there were multiple partners who displayed domestic violence and the instability of moving among states and schools. So when Sammy found out that her mother had sent a text that she was awaiting the documentation in order to return her to the home where Mr. Smith resides, that was when I, in talking with Sammy, decided that the best step was to make another attempt to get the emergency guardianship. Part of doing that was to request a watch background investigation that we went online and paid for, and that showed that Mr. Smith does have domestic violence in his background. It is some time ago. The other thing that caused for concern is that I think part of what's at play here is that Sammy has witnessed so much domestic violence in so many ways for so long that anything that looks remotely like domestic violence, she's more sensitized to. So when she was seeing behavior in Mr. Smith that mirrored initial behavior in past partners, I think that her reaction has been very, very sensitive to that whole thing. Since Samantha has been with us on September 11th, we have, we've worked with CPS, who was involved for a time. We have worked with law enforcement concerning a molestation that occurred with her from a past partner, not Mr. Smith. We've transported her to and from school. We've converted an office in the home to a private bedroom for her. The pursuit of legal matters has been predominantly at her guidance and her stated request. She has a petition pending under Cowlitz County 23-400-35308, requesting guardianship be given to me.
Is that, and I don't have that in front of me, but you said she's almost 18 years old.
Correct. She turns 18 on February 1st.
Okay.
Basically, what we're trying to do on Sammy's behalf is to ensure her physical, mental, emotional well-being and safety out of the residence of Mr. Smith, who displays actions and behavior that mirror past partners.
Well, right. I guess I'm, you know, appointing a GAL is not necessarily a bad idea. I do see that the father has consented again in this new petition. And then just to make sure, Ms. Gilliam, have you been served a copy of this latest petition by Ms. Cost?
I was emailed a copy of everything at 7 o'clock last night while I was on shift at the casino.
Oh, well, that's not proper service.
Well, Your Honor, we hired
hold on,
a server.
Ms. Has she been personally served with these documents?
She was finally served after a process server made 3 attempts. She made arrangements to meet with him before work on Sunday and then failed to show. He went to the home on the 1st to serve her prior to her going to work. And his statement reads, he was met by 2 teenage females who said she was not at home. I attempted again on the 2nd at 10:22 a.m. As I drove up the driveway, I noted a white male in the driveway working on Kirsten's vehicle. I also observed an unknown person run into the house. I knew the male from previous contact with Kirsten as her boyfriend and asked if Kirsten was home. He stated she was not. He stated he did not want to be involved with her court stuff and refused acceptance of the docs. I attempted to call Kirsten again and could not get an answer. So 3 attempts were made prior to us emailing her directly.
Well, so here's how this works though. If you have to personally serve her, if you can't accomplish that, then you come to court and you ask for permission for email service. It's not just something you do if you can't get personal service. So I'm just going to start with this because service is kind of the baseline finding I have to even move forward. So Ms. Gilliam, Are you agreeing to accept these documents by email service?
No, Your Honor, I would like hard copies delivered in hand, and I do not work today. So when the process server first contacted me, I told him that I had an availability window where before I had to go to work, and he did not show up by the time that I had to leave. The security company that I work for has me primarily positioned at the ALNA casino, and my schedule changes on a dime. I've watched in real time on my app as my schedule has changed, and based on my contract, I'm required to honor the schedule changes as they come up. I was told that he had attempted to come to the house, and one of the children that he talked to were Nick's daughters. They said somebody came up looking for me, and then he called me yesterday and said that somebody had tried to leave me paperwork, but I have had no further phone calls from the process server since the initial phone call.
Okay, so Ms. Cost, I guess the first thing I'll say is we do need to get this petition, the new petition, served personally on Ms. Gilliam. Let me also ask, is Ms. Brightmeyer, Samantha Brightmeyer, requesting to be screened for appointment of an attorney on her behalf? She does have the right to be represented by an attorney.
You have to say something, honey. You can't just nod. Okay.
Yes, Your Honor.
Okay, and do you currently work?
No.
Okay, are you in school full-time?
Yes.
Okay, I will find that you qualify for a court-appointed lawyer at county cost. I will get that order issued. As soon as I get a name of a person who will accept appointment on this case, I will let you know. Ms. Gilliam,
Your Honor.
hold on a second. Ms. Gilliam, I'm also going to ask you if you're wishing to be screened for an attorney.
Yes, Your Honor.
Okay.
I actually filed a motion for an attorney with the last hearing, and I would like to reaffirm that request.
I saw that, and it was maybe a day or so before the hearing. So were you ever, did the prior judicial officer talk to you about your right to an attorney and screen you for counsel?
No, he did not, Your Honor.
Okay. Well, I think since the petition was denied, that's probably the reasoning there. But I think in this case where we've got a couple things going on, we've got a new petition filed, and then I have concerns about compliance with the prior judicial order.
Well,
so not by you, Ms. Gilliam. I'm just concerned that right now what we have is we have two conflicting judicial orders. One says return the child, and then Ms. Cost refiled ex parte and had a different judicial officer sign a new emergency order. So we are in gray area where you both have two judges who are telling you two different things. One says return child to Ms. Gilliam, and now the other one has said on an emergency basis, Ms. Cost keeps minor child. So I do think that Ms. Gilliam, it is in your best interest to have an attorney appointed. What is your current income?
that depends, Your Honor. Like I said, my hours can change on a dime, so my income can range anywhere from 800 give or take to 1,200 a month.
Per month? Okay. How many, so let's even assume 1,200 a month. How many dependents do you take care of on that amount of money?
Samantha is currently my only dependent, so 0 at this point.
Just you?
Just myself, yes.
Okay.
I do contribute to the household for the household expenses, of course. And then fuel, I do have a garnishment on my wages from previous actions that were filed. And they take up to 25% of my wages.
Okay. So what's your take home every month? Kind of on a low end and high end.
Well, recently with the hearing and the way that I've had to kind of monkey tail everything due to the timing of service and trying to get everything put together, I think my income for last month was right around I want to say 900 or 1,000.
For the whole month?
Yes, ma'am.
Okay, I will find that you qualify for a court-appointed attorney. I will get that order, and as soon as we have a name for you, the court will let you know and the attorney will reach out to you. Do we have your most recent contact information? I have
Yes, Your Honor.
the Castle Rock address and then a phone number ending in 9822.
Yes, Your Honor.
Okay. Go ahead.
Well, I wanted to touch on something that Ms. Cost had said. When we had our last hearing on the 21st, I was texted by my mother not 30 minutes after the court hearing, asking if I would be willing to enter a temporary custody agreement based on the judge's opinion. Because I struggle with my own mental health issues, I have diagnosed manic depression, I have diagnosed CPTSD, and I did not respond initially because I didn't want to come off as being reactionary, or as my mother has called me in the past, as being irrational when I'm upset about things. I did not respond to a text from her until she texted me at 4:15 or around 4:15, 4:20 in the evening, saying that she had planned to bring Samantha back. I had mentioned in the court hearing, the judge said that there were some things that needed to happen before Samantha was actually integrated back into the house. And I told my mother that based on the judge's opinion, I was willing to let Samantha stay with her for the time being until those things could be completed, but that I was not interested in a custody arrangement. I have had, so my oldest daughter is turning 19 in December, and I have a standing order out of Oregon that was issued in 2006. I have sole custody of Samantha. I've been fully responsible for her entire life, aside from the 9 months that she was living with her dad in Kansas. Yes, there have been some issues with partners in the past, and I can understand Samantha's concern and her feelings of anxiety, but Mr. Smith does not exhibit any behaviors that come off even remotely close to anything that I have experienced in the past, or that we have been around in the past. I moved here August 10th, and since moving here, my mother has tried to talk me into letting Samantha stay with her for her senior year, at which I declined. She was trying to talk me into having her go to a Longview school, which makes zero sense because we live in an area where we can pick between 3 school districts, and because Mr. Smith's daughters already go to school, we just decided to have her go there. And then we had an incident where days before my mother came and picked up Samantha, Mr. Smith had to tell his children that their mother had passed away.
Yeah. And here's the thing, I think, and I think we're getting kind of far-fetched from where we need to be right now, because we don't even have service on you. So I'm not taking testimony on how we're going to ultimately decide this case. I see Mr. Smith's history. I see how old it is. We're going almost on 20 years. So this is that's not a linchpin of what I'm going to base this case on at all. I actually am more concerned that we've had a full hearing and a denial, and yet here we are again, kind of with no change in circumstances. We're just wanting to redo what's already been decided. So
I haven't had time to.
Nope. Yep. So both of you, Ms. Cost, I'm talking now. What I am saying is we need to get service. I mean, you can roll your eyes if you want.
No, I'm not. I was looking at Sammy because she wants to speak.
Okay. So the deal is we don't have service on Ms. Gilliam. I have a judge's order that actually denied your petition. So I'm not taking testimony today. I'm somewhat reluctant to even redo the emergency order that a new judicial officer has put into place, but I will today, very short-term basis, only so we can get an attorney appointed for Ms. Gilliam, and so we can get an attorney appointed for Ms. Brightmeyer. Ms. Brightmeyer, did you want to address the court?
Yeah, sorry.
It's okay. It's okay. Take your time.
Regarding abusive behavior or seeing that happen. The night I was returned to the house, I was trying to speak with my mother privately on why I had left.
Okay.
And from around the house, I heard Nick shout if I was so threatened by him, I could get the fuck off his property twice.
Okay.
And my mother had to tell him that is not what I was saying.
Okay.
And I genuinely do not want to go back to that house because of the years I've had to suffer being a piece of meat between her partners. To belittle, to humiliate, to harm. I don't want to go through that again, and I am seeing too many similarities to feel safe in that household, to a point I had texted my sibling, Hannah Brightmeyer, that I didn't feel safe and I needed to get out.
Mhm.
I'm sorry for crying.
Nope, Samantha, you're absolutely fine. I understand and I appreciate your input. I think it explains some of the additional reason why a new petition has been filed. So I appreciate your input. I think having an attorney appointed to you is a great idea in this case. They will be there to advocate for what you want, especially because you are 17 years old. I think that is important. Okay.
Okay.
So I appreciate you being here today. We are going to get an attorney appointed for you. I'm going to reissue the temporary order granting just emergency guardianship to Ms. Cost. Let's have you all, and Ms. Cost, you need to get that personally served on Ms. Gilliam. I'm thinking because it does take us a little time, especially to find lawyers for minors, I'd like to set this out 3 weeks to October 24th. That'll also give the GAL time to interview the parties. Are you all available October 24th at 10:30 a.m.?
I will be
Yes, Your
traveling
Honor.
out of town for work that day, Your Honor. Is it possible for Thursday, the 26th, perhaps?
No, I'm not going to put it back on that docket because that'll be the same judge who already heard this case and made a
Okay.
ruling. So I think you all need a fresh set of eyes.
Okay.
So I could give you,
Monday would work.
we only have these on Tuesdays and Thursdays. So it's going to have to be on a Tuesday. Are you able to Zoom in?
No, I'll be in a prison that day for work and I have no cell service from the prison.
Okay. What about the 31st?
Yes, that's open.
Ms. Gilliam, is the 31st open for you?
As far as I know, Your Honor, my schedule is made a week in advance, so that is possibly subject to change, but I can let my employer know that I need that day off.
Okay, or if that is a working day and we need to reschedule, you can reach out to the court. Or if it's a situation where they'll give you, a 15-minute break to do the hearing, when you log on that day, let the court know right away that you have a work obligation that you have to get back to, and we'll get your case called first or last, depending on the timing of your break, okay?
Yes, Your Honor. So the 31st to 10:30?
10:30. Yep, same Zoom link. It'll be the minor guardianship docket. I'll get the orders issued, just extending the immediate order through that date. We'll get a lawyer appointed to both Ms. Gilliam and Ms. Brightmeyer, and then we'll be back on the 31st, okay?
All right, thank you, Your Honor.
All right, thank you.
Present potentially on the Brightmeyer matter. It's number 5 on my docket. I was appointed under the emergency guardianship. I know that this is on for the full guardianship. So I appear today just in case the court wanted me. It was going to be my request that this be set over to the 31st to be heard in conjunction with the emergency guardianship.
And Mr. Anagnasto, you're on this case as well, correct?
I am, Your Honor. I was appointed to represent the mother, Kirsten Gilliam.
Okay. So let's call that matter 234-0035-308. And I believe I have Tammy Cost online. She's the proposed guardian in this case and the tracking
The video.
case. And I have Ms. Gilliam present. And usually with Ms. Cost is also Ms. Brightmeyer, as she is 17 years old. She usually appears. Is she there in the room with you, Ms. Cost?
She is not today.
Oh, okay.
No, Your Honor. Your Honor, I did tell Samantha that she could be at school today instead of being in court for purposes of today. I anticipated a set over.
Perfect. That is, so I'll just tell the folks, this is what I saw on this case as well. So we have Ms. Cost originally filed for emergency guardianship. And that's under a different docket that I've already set to October 31st. Ms. Brightmeyer, on her own accord, filed for this minor guardianship and asked to have counsel appointed. I reviewed under this docket her request for counsel and denied it ex parte only because we had already appointed Ms. Bliss on Ms. Cost's emergency minor guardianship case. So what I would like to do, absent any objection, is simply consolidate these two matters and have it all heard on the 31st as originally proposed. Is that okay with everyone involved? I think I'll start at Ms. Bliss. It sounds like that was your request anyway, so you're probably in agreement.
That is correct.
Mr. Anagnosto.
That is not okay with my client. Her daughter is suffering from mental health issues and it's untreated, and she needs her return sooner than later.
Okay. And Ms. Cost.
That it works for us. Ms. Brightmeyer is in mental health services and has been for a couple of weeks now. So her needs are being met.
Okay. Go ahead, Ms. Gilliam. You do have an attorney, so you're free to talk to the court, or I can give you a breakout room with your attorney.
I was not aware that she was in mental health services.
Do you all want a breakout room to talk about this?
Me and my client?
Yes.
No, I think because my client is way more knowledgeable about the facts. I've been reviewing it this morning, trying to get up to speed. I didn't realize I was on this docket, but if the court would just indulge her to hear from her, but it sounds like she wasn't aware that her daughter was in mental health, and I'm not sure if she has any input regarding that.
Okay. So Ms. Gilliam, you do have an attorney now, so I don't want to, force you to say anything. I think the question is just because when we were all together last, we had set the October 31st date. Do you have an objection to us consolidating this case and hearing it all on the 31st, knowing now that at least by Ms. Cost's assertions, she is in mental health treatment?
No, Your Honor, I'm fine with consolidating everything.
Okay. So it sounds like, and I do think just out of economy of fact finding, I do think on the 31st that will also give the attorneys who have recently been assigned more time to prep for fact finding. I will just note kind of historically, this is a case where Judge Warning already had a fact finding and denied the petition. And so I guess I just want to give the attorneys plenty of time to prep for what sounds like maybe some facts that came up since that denial. And it doesn't sound to me like this is a case where we're going to just do a bunch of continuances. I do really believe we'll move to a fact finding on the 31st since we've kind of already been there once. Okay.
And Your Honor, just procedurally, the fact finding, is that going to be testimonial, or does everything have to be done by declarations?
I will allow some testimony. I guess what I'll tell the parties is my preference on the emergency guardianship fact findings is that it's pretty limited. If you all think you're going to be spending more than 30 minutes on the case, I would want to set it to a different docket. I mean, technically we set this docket for 1 hour to hear everyone's minor guardianship cases. So if you think that testimony is going to be lengthier, let's maybe get this noted on an earlier docket and get you special set or something like that. But typically what I've done is allow parties about 15 to 20 minutes of testimony that I'll consider in addition to declarations on the emergency piece. And then if we need to trial set for the full petition, we certainly can.
Okay, very good, Your Honor.
Okay. Okay, so what I'll do is move this over to the 31st. This one does not have any sort of guardianship order that I need to continue. That's already been done on the emergency case from Ms. Cost. So we'll see you back on the 31st.
Thank you, Your Honor.
Thank you, Judge.
Okay, thank you all. There's
Your Honor, I'm present on the Brightmeyer matter numbers 5 and 6. I wasn't necessarily going to be requesting a set over, but given the court's position today, I'm also currently in 2 places at once on the domestic docket. I have 4 matters currently waiting to be heard on that docket. There has been a lot of movement, at least from my client and the petitioner's behalf. I do note that a lot of materials were maybe filed yesterday or within the last couple days, and I don't necessarily think that they were served upon all parties. So I think everything included, I don't think it would be a bad idea to set this over at least a week.
okay. And then I think I do also have, do I have Mr. Anagnosto on this one on behalf of the mother?
Correct. And I don't see him here this morning.
Don't see him yet. I'll keep an eye on the waiting room. Ms. Cost, I do see you there.
Yes.
Do you have any objection to a set over? I do see filings from Mom. And Kirsten, are you with us?
Yes, Your Honor.
Okay. Have you been in touch with your attorney, Mr. Anagnosto?
He called me this morning and said that he was going to be here at the hearing today, but I don't see him either. So I'm not quite sure what's going on with that.
Okay, we'll give it just a minute. So I'll wait for your attorney. Ms. Cost, what is your position on a 1-week set over to next Tuesday at 10:30?
I believe that works fine for our schedule. Let me double check that.
Okay. We would be just extending that immediate order just 1 week through that date.
Tuesday, the 7th does work. I don't know what was necessarily filed from Ms. Gilliam recently, but I have not received anything from her.
Okay. Let's see, I still don't see Mr. Anagnosto. If you all hold tight, as soon as he logs in, I'll just get his position on the brief set over, and then I'll recall these 2 matters.
Very good. Thank you, Judge.
Brightmeyer case, if you're ready.
Yes, Your Honor.
And I was saying, I started docket just a little bit early. Unfortunately, for those who were with me last week, this is kind of a broken record. I'm in between 2 ITA hearings at this exact minute. So I am cases that are likely to be set over anyway. I'm going to try and talk about first, but in all likelihood, most, if not all cases will need to be set over to Thursday or Tuesday. In talking to the other parties, it sounds like there's been some additional filings by your client, Ms. Gilliam, that haven't yet been served on all the parties. So we would likely be doing a set over anyway. Do you have any objection to moving this to next Tuesday at 10:30 a.m.?
No, I mean, I believe well,
It looked to me like Ms. Gilliam filed
some additional information. Yeah.
some several pages of text messages that haven't been provided to the other parties yet. So we would likely be doing a set over anyway.
I have a week of trial next week. I'm not sure what day it's going to go. I won't know until the 11:30 docket today.
Okay. Why don't we set you all, or Ms. Bliss, did you want to?
I don't have any objections to 2 weeks if that works better for Mr. Anagnosto, or we can set it for next week with a little caveat that if he has trial at that time, we might need to renote it anyways.
And Mr. Anagnosto, I'll leave that to your discretion. Ms. Farr, did you have
Yes, Your Honor. I would like to ask for 2 weeks because I've only made contact with mothers so far, and I
Okay,
haven't had time to interview the other parties.
so then why don't we, let's do November 14 at 10:30. That gives everyone time to receive documents and respond if they want. It'll free up the stress of having to reach out to the court if you get set for trial on Tuesday. And then Ms. Barr will have additional time to speak to the parties. Does that work for everyone?
Yes, it does, Judge. Thank you.
Okay, so I'll get that emergency or the immediate order extended just through November 14. All right. Thank
Thank you,
you
Judge.
all. Just on my docket, the two matters that have been combined, the 234-0034-208. It is set for both approving a petition and a show cause on the emergency minor guardianship. I think everyone that is online with us is on this case. Let me just double check here. I have Ms. Bliss, I have Mr. Anagnosto. I have Kirsten. I have, I assume the W cost. No, I can't assume that because I see Tammy Cost, you have your own video.
Yes,
Okay, and then who is under W cost?
my husband and Sammy's grandfather.
Okay. And then I have a Miranda Smith.
I believe she's the child of Mr. Smith and mother's partner.
Okay. And then Nicholas Smith, you're online with us, I see.
Yes, Your Honor.
Okay. Well, let me turn it over first to the two attorneys, Ms. Bliss on behalf of the minor child, and then Mr. Anagnosto on behalf of mother Kirsten. How are you asking the court to proceed today?
I was hoping we could hear from Ms. Farr. I know we set this matter over 2 weeks from our last hearing, so Ms. Farr could, I think, make contact with the parties and at least begin somewhat of an interim investigation. So I would say maybe chatting with her first. My client's obviously still wanting the minor guardianship to be approved today, so I guess dependent on where we go from there.
Okay. And then Mr. Anagnosto, what is your request of the court today?
Sorry about that.
Nope.
I would agree with that suggestion by counsel that we hear from Ms. Farr and then go forward.
Okay. Well, Ms. Farr, we're putting you in the hot seat now. Checking in with you kind of to see where you're at on this case.
Yes, Your Honor. So I have interviewed several of the people involved in this case. I still have a couple more interviews to complete. My opinion at this point is that the child is safe and doing well in the grandmother's care, and she should remain there for the time being until the investigation is completed and the court can make a ruling.
Okay.
She's going to school. She's safe. She's well taken care of. Mother has provided me with some documentation that I haven't had time to thoroughly review yet. And I just need more time for more investigation. I have been under the weather for the last week, and so I just haven't been able to do more than I have.
Yeah, no, completely understood. It hit me last week and really threw me down. I tried to do court with no voice, all the things. So I guess let me turn it back over to the attorneys first, and then I'll come to you, Ms. Cost. It sounds to me, and I'll tell the parties, I did also receive from Mr. Anagnosto's filings, it looks like some concerns, I assume, that are going to be raised about attendance and grades of Samantha. But my thought is maybe a short set over so Ms. Farr can complete the investigation and then we can come back with a hearing. I'm assuming the parties are going to want time to prepare for that type of testimony based on whatever, Ms. Farr's ultimate recommendations will be following full investigation. But that's just my thought. I'll turn it over Mr. Anagnosto and then Ms. Bliss.
Yes, Your Honor. We're asking that this matter be dismissed. There's no additional basis from the original filing. It's basically just a rehashing of the original filing that was dismissed. You know, for all intents and purposes, you have a nearly 18-year-old child here that's going to be 18 in February, so a couple of 3 months out. You know, my client can't force her to come home. So this matter gets dismissed. She stays, you know, living at grandma's house for the next 3 months, and then she's 18 and she can make her own decisions. Some of our concerns and why we think this should be dismissed and leave basically the parental rights in my client's hands is where she's going to school. Currently, she's going to school. Submitted the grades. If the petitioner has, one of the reasons this action was brought was the petitioner asked that my client let Samantha go to. My client said no, she's going to. And we suspect that if this is granted, she's going to move her to. Clients looked into it. Samantha will have to start the 12th grade over again. She would basically be going back into a junior year instead of her senior year, and then start 12th grade again in Longview School District. And it's just setting her up to fail. The petition, there are no facts stated by my client, by the mother, of any issues in her household other than they've made vague allegations against her current boyfriend, the person she's residing with, Mr. Smith. You know, the court already dismissed it, this action based on those. You know, this is what we have. This is the real issue, Your Honor. My client took her daughter's cell phone away. Her daughter, Samantha, is doing very dangerous things with cell phones. She's in internet sites. She has supposedly an international boyfriend that she wants to go visit that, you know, would require her to leave the country. And I forget the country where this boyfriend lives, but giving her mental health issues and her struggles, this is extremely dangerous. So my client takes her cell phone away, and here we are. You know, the court needs to support parents trying to parent their children and give them the tools they need to be successful. Samantha has significant mental health issues. My client was dealing with those, and has this issue with regards to cell phone and internet abuse. My client was dealing with that from her point of view appropriately, and here we are. So we're asking that there's no new facts stated from the original petition. It's just a rehashing, that my client be supported, that this matter be dismissed. She can't physically drag her 18-year-old daughter out of her mother's house, but you know, things would just kind of stay the same. She would be residing at the grandmother's house, going to and they would, you know, a family needs to work together to get you know, a child over the finish line into adulthood, and that's all my client's trying to do, and she's doing a good job and needs to be supported.
Ms. Bliss.
Thank you, Your Honor. And for the record, I do represent the minor child in this action. And counsel's resuscitation of the case is interesting, and is precisely why Samantha needs protecting. Mom is constantly minimizing the exposure that this child has been exposed to domestic violence, dangers within the household, failure to protect, potential neglect. These are the reasons that this matters before the court. Mom Mom's position is a little interesting. She doesn't want the minor guardianship to be approved, but she also doesn't want the child home. And I think that that's very telling in her own statements that she's provided to the court. She has no faith in her ability to parent this child, at least as of right now, regardless of the reasoning. Since going into grandma's care, my client has been enrolled in counseling and is actively engaged in counseling. She is attending school. If Your Honor did look at the attendance records, yes, she has missed some school. She also has 4 active litigations happening right now. So there's a lot of court time that she's having to miss school to attend court. And I also think it's interesting looking back at Mom's declaration submitted to the court. Failing grades and failing classes is not new for Sam. Unfortunately, she struggles with some school, and Mom acknowledges that even in her own declaration. To now say that, oh, now that she's been in Ms. Cost's care, now she's having trouble in school, now she's not attending school, she's failing to see the issues here. And I definitely think that that is precisely why Ms. Farr has been appointed to investigate. I think we need to allow her the opportunity to investigate, to determine what is best for Sam. As of right now, she is safe, she is happy, she is thriving. I think dismissing this action today without all of the facts would be an error.
Ms. Farr.
Your Honor, I would just add an additional comment that if the guardianship were to be dismissed, even if Sammy did stay with the grandmother wouldn't have any authority for decision making, even if it was just for the next 3 months. So it's necessary to have the emergency guardianship in place for that reason alone.
And Ms. Cost, is there anything you want to add before the court decides this motion to dismiss that's been made orally?
When Samantha came to my home, she did not have medical insurance. She was not in services for this undocumented claims of her having schizophrenia. She was in a new school, according to what Sam told me, the 5th high school since beginning 9th grade. She saw patterns of behavior in her mother's partner that were very reminiscent of prior partners that escalated to domestic violence and outright abuse. And some of those claims have been substantiated by a statement provided by her sister that has been filed with the court. I had said many, many times that if the girls were ever unsafe, they could call me. I would come get them. We wouldn't talk about it that night. It didn't matter if it was a party. It didn't matter what it was. We wouldn't talk about it that night. We would talk about it the next day. My daughter was aware of that. When Samantha called me, that's what I did. I have made efforts to talk this out, to no avail. I have returned her once after being told that grandparents have no rights to their grandchildren in the state of Washington. And within about an hour and a half, she was back in my custody per my daughter's instructions. Since then, we go through times of she can stay with us. And then I get these demanding, ranting text messages after I've gone to bed, demanding I produce the child and all of her belongings within an hour. And in the next minute, it's okay to stay with us. I've been able to secure her medical insurance. She is in counseling. She just began a medication for mental health. To the best of my knowledge, her diagnosis is not schizophrenia, and there's been no documentation provided to me stating that she has that. She is struggling in school. This has been very stressful for her. When Sammy first came to me, she wore clothing that was double the size of what she needed, and she hid in her clothing and she would hide in the bedroom. She now wears clothing that fits. She comes out of the bedroom. She engages with us. Things are not perfect, and there's going to be struggles moving forward. She's got a lot of work to do. But for this to be dismissed, I have no reason to believe after Kirsten's text that as soon as this is over and Sammy returns to her house, that we will have no contact with Sammy. We will have no access to Sammy. There's been conversations about online schooling, which would remove the ability of the school staff to intervene if it went sideways. And I just don't see even though we're this close to Sammy being 18, that in any way protects her if her belief about the escalation of domestic violence occurs.
Okay. So here's my ruling on the
Veronica,
motion.
can I just make a quick comment? I'm sorry.
Of course, go ahead.
So my client wants to testify and respond to all those allegations. She denies
Of
those,
course.
I'll leave it at that. I mean, that was testimonial, and she hasn't had her opportunity to have a say.
Understood. And I am not taking any of this as sworn testimony. I'm taking it as argument and giving it the due weight that it is entitled in such a situation. Here's what I'm going to do on the motion to dismiss. How I'm looking at this is from a baseline standard of, do I believe that there's enough information in the file that I would grant an immediate order, ex parte or otherwise? And what I see, so this case did go to hearing originally in September of 2023. There was testimony taken. What I think the court must always strike a balance between expediting decisions for parties, all parties, and actually determining if there is a parent able and willing to undertake parental functions. I think that, I guess my concern is there was no attorney appointed to the minor when that testimony took place. I'll also note for the record, Ms. Gilliam requested an attorney the day before or the day of that hearing and wasn't appointed an attorney, and the hearing went forward. There was no guardian ad litem to investigate the allegations or the parties. So I'm not here to say whether the first judicial officer got it right or wrong. That is not my place at all. I just think we have the appropriate safeguards in place for all parties. We have an attorney for the mother, we have an attorney for minor, we have a guardian ad litem now. I think that we are better situated to make a decision about whether there is a parent able and willing to perform parental functions. And when I look at the definition of parental functions, I think right now, just looking at what's pled in the file, which does also include statements from other children of Ms. Gilliam, I think there is a there's enough for me to make a threshold filing that this matter should not be dismissed, but should be set for a show cause after Ms. Farr completes her investigation. What I'm specifically looking at are a couple of things. Parenting functions includes those things like maintaining a stable and consistent relationship with the child, attending to their daily needs, including supervision. It includes assisting the child in developing and maintaining appropriate interpersonal relationships. It also includes exercising appropriate judgment regarding the child's welfare. So I think what I have here are allegations from the minor who is almost an adult. So I have to take that into account. This is not a 4-year-old or a 7-year-old or a 10-year-old even, who has concerns about whether her mother can give her that stable, safe, consistent environment given the mother's choices in who she brings into the home. So I'm looking at it from a lens of, I'm not making a decision about whether Ms. Gilliam is able and willing to perform those parental functions. I want to set that for a show cause hearing. I'm just stating here today that I do think there is new information since the original order, I think, or decision, that there are new safeguards in place, specifically an attorney for the minor so that her voice is heard. And so I think that there's absolutely a threshold showing that the immediate order should be reissued until we come back on a show cause. So that'll be my ruling today. I would just state, I did see the filing, the concern about grades and attendance, and my hope, Ms. Cost, is that I understand the arguments of Ms. Bliss that certainly being involved in litigation and having to file for protection orders and things like that can certainly impact probably Samantha's ability to focus on schoolwork. But I am hopeful that you're able to maybe reach out to the school and get her some resources to really increase attendance, increase grades. Those are all things that the court would like to see. So I'm encouraging you to do so. I can issue a bench order if the parties want, denying the motion to dismiss the petition and setting for show cause. What would be the date the parties would want for show cause? And I might first turn to Ms. Farr, because I think the investigative piece falls on you. So I don't want to push you too far. I know you're one of 2 GALs we have on this docket, and I take that into account.
With the holidays in between, I would say at the minimum, the 19th of December.
I think given the likely contentious nature that this case will take and the number of witnesses that may provide declarations or want to testify, I think setting it out that far probably makes a lot of sense, so both attorneys can be prepared. Are you both available on the 19th?
That works for me.
That works for me, Your Honor.
Okay. And Ms. Kosk, will that work for you?
Yes, it will.
Okay. So I am going to reissue the immediate order, having made that finding of a threshold showing of its need just through December 19th at 10:30. I wrote PM. Please don't log in PM. I'm going to correct that to AM. And we'll see you December 19th at 10:30 AM.
Thank you, Judge.
Thank you.
I want to just do a little bit of administrative housekeeping before we go too far. On the Brightmeyer matters, that's numbers 4 and 6 on our docket. If those parties could unmute, I want to get a sense of, I have received filings since our last hearing. We were originally set for an evidentiary hearing. I see that there is a power of attorney signed that, although I understand there's some issues about possessions, appears to resolve the guardianship issue. So I want to check in with the parties and see what their thoughts are on this.
Well, Your Honor, on behalf of my client, the mother of Samantha, that's her position. She wants out of this litigation. She wants this litigation done. So she signed a power of attorney to the petitioner party, Tamara Coast. So Ms. Coast now has a power of attorney over Samantha, and this case should be dismissed.
Ms. Bliss.
Thank you. And for the record, I do represent Samantha Brightmeyer, the youth in this matter. While I would agree that the power of attorney essentially gives Ms. Cost the ability to continue caring for Samantha, the issues still remain regarding the possessions. And my concern is if Your Honor were to dismiss the guardianship today, that those issues would be left unresolved and there would be no remedy to get those possessions back to my client. I did receive a filing from Mr. Anagnostu's office yesterday at about 4:30 with his client's position on returning my client's possessions, but I haven't had the opportunity to really speak with my client regarding those. But again, my concern is if we dismiss the guardianship petition, both guardianship petitions today, that those issues will be remain unresolved and we wouldn't have any remedy to get those possessions back to my client.
Okay, thank you, Ms. Bliss.
Your Honor, this is Tammy Cost.
Yep, ma'am, I'm coming to you next. So Ms. Cost, I see the power of attorney. Please give me your position on whether you're voluntarily dismissing your petition today or not.
I am not voluntarily dismissing the petition, and I'd like to clarify my legal name is Tammy, not Tamara. My family happens to have 2 sisters-in-law with similar first names, and I don't want my case confused with issues that Mr. Anagnostu's office has represented my sister-in-law in the past.
Have not called you Tamara.
No, ma'am.
The court filings reference you as Tammy. You're logged in as Tammy. So with that noted, please go ahead.
Okay. I agree is that property has been a huge issue. And trying to get property back has been not good. Basically, when Samantha originally arrived at my house, she had a duffel bag and a couple other items, and that was it. And we were told that we weren't going to get any other items. If my guardianship request is dismissed, then there is no recourse to get the property. There's been no communication from Ms. Gilliam that I'm aware of pertaining to how we're going to work this out. There was a comment made that she planned to drop some property at my husband's place of employment, but with not knowing how much that might be. And with that being an employment place with other employees and him not wanting to have legal matters, personal matters displayed before coworkers, we were opposed to that being a drop-off site. We are open to independent or neutral sites. And that once the property is returned, then I would submit to have the guardianship dismissed.
Well, my concern here is that I am being asked on this docket to insert myself into transfer of possessions that I don't believe the Minor Guardianship Act gives me authority over. I am happy to be wrong about that if someone wants to tell me I am wrong. But here's my initial perspective after reviewing the materials. I am willing, again, to be wrong on this if someone has authority, but my take is this was filed for emergency minor guardianship. My role is limited to whether I believe there's a parent able and willing to care for the child. Now we have a power of attorney that transfers that right. I feel as if the matter is moot. I don't think that there's an issue that can be litigated in front of me on this docket under the minor guardianship pleadings. So my gut instinct is that I do have to dismiss the petition today. That is not to say that there isn't some other forum in which possessions could be fought over, but I'm not sure it's here. I'll first maybe turn to Ms. Bliss. I know this is kind of putting you on the spot. But I know since you argued for this state in front of me for possessions, let me know how you might disagree with me, and we can then, I'll make my final ruling after I hear from the parties again.
And while you were speaking, I was trying to pull up the RCWs to determine and point you in the direction, but I do recall in my past of working in these cases, the court can make at least temporary orders or orders to the effect of transferring the minor's possessions. I would agree with Your Honor's procedural analysis of if the guardianship is dismissed, that you essentially lack the authority to continue to make orders within that. I guess at this point, I would just ask the court to make whatever ruling you're going to make, but allow me to bring this matter back before the court if I find legal authority to revise or reconsider your decision today.
Would it be helpful, Mr. Anagnosto, I'll come to you. My other thought as I was prepping this case was, because this isn't an issue I've had in front of me before, if we could get it done in short order, I'll be off this docket after next week. But if the parties wanted a week to submit briefing on this issue, I would be happy to put this on. I know holiday schedules. I'd be happy to put this on next Tuesday's docket. We only have one other case that day to allow time for briefing on the issue of possession of transfers and whether that truly is within my jurisdiction. But so I'll throw that out there as an option.
I guess my initial reaction, Your Honor, is I agree with your first position that the guardianship statutes are just that with regards to guardianship over, in this case, a minor, or it could be an adult. They really don't deal with personal property. I'm court appointed, and I'll do research and brief this issue, but I think your first impulse is to grant the dismissal, which this case needs to be dismissed. And then that would I would submit my discharge and billing statements to get paid by the county and be done with this case. I'm looking forward to being done with it as well. And I think that's the appropriate way that we go at this point. If you want to set it over a week for entry of an order of dismissal, and Ms. Bliss can do research. I just don't think I agree with you. I just don't think there's authority over personal property, nor should I be expending, legal time briefing the issue and responding to this. But here we are.
Yeah, and I'm looking at the statute right now, looking under duties of guardian. And I just don't see, it does say under duties of the guardian, take reasonable care of the minor's personal effects and bring a proceeding for conservatorship or protective arrangement if necessary to protect other property of the minor. So based on my, again, I could be wrong. I take no ego in this, but I think all I can do today is find that continuing with a minor guardianship proceeding is moot, given the power of attorney. I am going to dismiss. I will indicate that dismissal is without prejudice if it needs to be re-raised and if parties find authority for me taking on this issue of personal belongings. But it would appear to me under 11-130-230-2B, now that the power of attorney for the guardian is in place, or for the minor by the guardian is in place, the remedy for personal effects would be a protective arrangement or conservatorship or some other action, could in fact be contractual in nature, given the language of the power of attorney. So that's going to be my ruling today. I can prepare that order so you all don't have to appear back on the docket. Does that next week on the day after Christmas, does that work for the parties?
That works for me.
Your Honor, if I may, this is Sherry Farr, the court visitor in this case.
Go ahead.
11-130-575 allows for the transfer of property without the appointment of conservatorship in the proceedings.
Transfer for benefit of minor without conservatorship. Let me pull that up.
And that says assets or other property.
So unless a person required to transfer funds or other property to a minor knows that a conservator for the minor has been appointed, the person may transfer an amount or value not exceeding $15,000 in a 12-month period to a person, a guardian, a custodian, a financial person that receives right for a minor, may apply it only to the support, care, education, health, and welfare of the minor. Funds not applied.
I know that sounds like monetary assets, but it does say under 2 other property.
It does say other property, but then when it talks about the sections under this, it has to be used for, the support could arguably be under support. I just don't think it's saying that it's an allowable act. And I appreciate you bringing this up because, again, I've never had this in front of me. So I appreciate you pointing out the statute. I still don't think this gives me the jurisdiction to decide who properly owns or has or should control the property. This statute seems to say we will allow transfer of property under a certain threshold amount in a 12-month period. So I think that is really helpful, and perhaps that will dictate how the attorneys choose to move forward on this issue with the possessions. I am going to go ahead and enter my dismissal again. I do think it's moot as there is not a guardianship decision in front of me to make. Ms. Cost, you said you wanted to be heard. Go ahead.
Excuse me. One of the things that I needed to point out is I understand that there was a last minute filing last night. I was made aware of that 15 minutes before the start of the hearing.
Okay.
The email by which it was sent, first of all, we had said we don't want service by email. Service was supposed to be done in person over to my husband's place of employment. And part of the reason for that is that people get our email address incorrect. Based on the routing of the email that was sent at 4:30 yesterday, our email address was incorrect, and that is why we did not receive it until 15 minutes before the hearing.
Understood. And I'll just note, I did receive that document late yesterday as well. It appears to me to be limited to the dispute over possessions. And I am declining to take jurisdiction over that dispute here today. So I'm going to find that, obviously, Ms. Cost, I understand your argument, but it wasn't used in my decision today. So I am not finding that there's been any prejudice in the filing to you. My ruling is really based on your filing to me, which was the inclusion of the power of attorney document that shows me that the guardianship has transferred to you and is irrevocable for the next 6 months. So that the minor is going to be with you until they are 18. Okay, I'm going to get that order issued. Is there anything else we need to do today?
Just a point of clarification, Judge, since you're entering that order today, I know we discussed a hearing next week, but we wouldn't be having a hearing next week, I imagine.
No, we will not. If you and Mr. Anignacio and Ms. Cost all decide that there is a possession issue, I guess that you want to note on this docket and you have some authority for it being properly on minor guardianship, we do have room. We only have one case. So if I'm going to come to work the day after Christmas, I'm fine taking a second case, but otherwise no need to appear.
Very good. Thank you, Judge.
Thank you, Your Honor.
And then, Your Honor, do I have your permission to submit my fees ex parte?
Absolutely. Thank you, Ms. Farr.
Thank you.